A very good evening to one and all present here. I welcome you all to the webinar on Supreme Court rejecting the PIL for formation of National Commission for Men, organized by the Amicus Curie. I am Pratiksha Bira and I will be the moderator of today's event. Before starting the meeting, I would like to inform you about some guidelines to be followed throughout the meeting today. Please keep your videos turned on during the session. Keep yourself muted during the session. You can unmute and ask questions to the speaker during the question and answer round. If the speaker allows you to ask the question in between, you can do it, but it's upon the discretion of the speaker. I would like to say some words about the amicus curiae. The amicus curiae is the brainchild of several legal luminaries and eminent personalities across the country and the globe. THU is a dream online platform which aims at proliferating legal knowledge and providing an ingenious understanding with cognizance of various fields of law to make sure that legal knowledge and experience penetrates to every nook and corner of the ever-growing legal fraternity. Through ambitious and studious legal brains across the country, THU aims at providing valuable contribution to contemporary legal issues along with contribution with development in the omnipresent field of law to the masses. We are also registered under Indian Partnership Act 1932 and Ministry of MSME, Government of India, and are also an ISO 9001 2015 organization. The Amicus Curiae is presently the eighth largest legal website in India. We are connected to more than 20,000 law students from across 80 plus law schools in India. I would like to introduce Ms. Mitali Arora ma'am to all of you. Being a WIPO and University of Torino alumni, Mitali ma'am's sense of heterogeneity and diversity stems from varied and intense background of on-law field experience in intellectual property rights and family law. She has been practicing law for more than a decade worth of experience and has been involved in several important cases within India and abroad, from patents to trademarks and copyrights to licensing and technology transfers to IP audits and IP assets. Due to diligence, she has extensive experience in client portfolio management. She provides strategic advice to the client on protecting valuable intellectual property. Ma'am is known for her outstanding management skills and has managed large IP portfolios of Fortune 500 companies globally. Along with IP laws, Ma'am also practices in the matters pertaining to family law with a specialization in divorce laws, child custody, maintenance, and domestic violence. She is fueled by the passion for understanding the finest details of law with a constant desire to achieve success. Ma'am, I request you to take over the meeting.
Thank you so much, Pratiksha. Thank you so much for your kind introduction. Good evening, everyone. I hope this is going to be an interesting session for all of you. And as Pratiksha mentioned, the Q&A round will be at the end of the session. It just helps keep the flow of the session better. However, if there is a pressing concern, then you may raise your hand and ask that question. But my humble request would be to allow me to finish that particular topic that I'm mentioning, and then you can ask your question. Of course, as I said, it would be best if it's at the end of the session. Having said that, thank you for the introduction, Pratiksha. Many kinds words spoken there. I am actually glad we're touching base on this topic today, which, if I dare say, much warrants and is the need of the hour, keeping in mind various aspects. And, I can personally vouch for it because, as Pratiksha mentioned, I practice family law, in Uttarakhand and even Delhi for that matter. And in my 11 years of experience, we have come across various cases where, again, not touching and stepping on anyone's toes, we have seen men being falsely implicated. In fact, very recently, we've been handed over an entire portfolio of cases, and I say portfolio, and please understand this is a bunch of, almost, a dozen cases upon a single man, initiated and instituted by his own family, his wife, and she has obviously included her children in it. who are majors, not just minors. And this is a retired professional that I'm referring to. And as I said, the number of cases that are against him, with the kind of evidence that we see, as lawyers, we don't get personally attached to cases. We prefer keeping it very objective, but evidence speaks, and that's what speaks in court as well. And when you see evidence which clearly shows that a man has been falsely implicated, it is a very hardening and heartening situation in terms of how these cases, and many have said certain provisions in law act as legal terrorism. And when you get to see it in person, in reality, you realize what is the dire situation. Of course, uh, you know come across all these kind of cases, whether it's related to men's rights or it's related to women's rights. And having dealt with both sides of the coin, I have come to, an opinion, formed one, and again, as I dare say, it's a personal opinion, that the need of the hour is not men's right or women's rights, it's gender neutrality. The need of the hour is equal rights. And I think if the real essence of feminism is also looked into, or men's right is also looked into, it is in essentiality. I'm sorry, I think the light. Yeah. Am I visible, Pratiksha?
Yes, ma'am.
Yes, ma'am, you are visible.
In case there is a break in voice, or in case there is a break in video, please do let me know. Right. So
Sure, ma'am.
going back to what I was saying, I am strongly of the opinion that it remains the fight of equal rights. It remains the fight for men and women both. But we are going to focus today on men's right, and the topic, rightly so, being Supreme Court rejecting the petition for National Commission for Men. Again, this menace that has been inflicted upon men of late, is it actually a menace? What do the statistics state? What are the laws out there? And how is our judicial system helping us safeguard the rights despite no such commission existing? And as to what this commission, if it were formed, would have done. And was it that this particular PIL was focusing on what a national commission usually does, or was it focusing on a narrow version of it? Something that we would aim at covering today through this webinar. So without further ado, I'm going to share my screen so that I can share the presentation and we'll move ahead. Is the screen visible?
Yes, ma'am, it is visible.
So yes, the most awaited topic of the day, unveiling the silent struggles, men's rights in today's society. In terms of men, as I said, equal rights, men's rights here is something that many, people have come out to say that there is a counterclaim to this, that it's a propaganda against feminism, it's a propaganda against women receiving their rights. But I think that's a very misconceived notion and a myth when it comes to these rights, because the people who propagate these rights, the people who stand by men's rights, especially many activists, and some of them being female activists, have time and again mentioned that their aim is not to demean or belittle any kind of rights or rights of equality. They also stand on the same ground as rights for women do. And those grounds are that women and men should receive equal rights. No section of the society, no gender should be, disproportionately represented, or no gender should receive any kind of bias basis their gender, whether it's men or it's women. I'm just going to start with a disclaimer. Of course, this is just for educational purposes. It may or may not contain updated laws, facts, and information. MAC law does not focus on exclusive rights for any one gender and advocates for gender equality. Yes, so as I said, feminist issues have been in the forefront a lot lately. And it is essentially human rights that we're talking about. So, should it be just about women? Should it be just about men? Or should it be about human rights? Because as we speak today, many of us, have come across that it's not just these two genders that we've been referring to of late. There are many facets to gender equality these days, and rightly so. One should be allowed to represent him or herself in any manner that they wish to. So, again, is it just about men or is it about human beings? And should we not be focusing on that? So, in that sense, the crucial approach to these issues constructively, working collaboratively, is to create a society that acknowledges and addresses the rights and concerns of all the members of the society, irrespective of their gender. So, this movement, the men's rights movement, where did it begin? What is it all about? Why are these people projecting for it? Again, it's composed of various rights and various people who, propagate it. The proponents of this movement support, as I said, gender neutral legislation and repeal of laws that they consider are biased against men. Indian rights activists have time and again picked up on legal issues such as anti dowry laws, divorce laws, child custody, which they believe are biased against men. And I'll give you a very small example. Again, I say this with first hand experience. Most lawyers tend to tell men when they come to them, including me, we say, really sorry, sir, we highly doubt that we'll be able to get the child custody for you. We will try our level best, but will we be able to guarantee it to you? No lawyer in his right mind will ever promise that, because the reality, the ground reality when it comes to child custody laws is grim. And I dare say it is rarest of rare cases that men are granted custody of the children, especially a girl child. However painful the situation is, it has become a norm, procedural norm. Not all cases go to the high courts and the Supreme Court. They're handled at the district court level. And at the district court level, and again, this is pan India that I'm referring to, this is statistics that show it, that it is very rare that child custody is granted to men. Men's right movement here, in terms of rape cases, fear of false accusations. Some men's right activists also consider that India's rape reporting laws and sexual harassment laws in India are so biased that, and they are so, again, being a woman, I know how I feel when I walk across the street, and that yes, I am, uh, you know, obviously privy to and understand the ground fact of the matter, that yes, there are many crimes that are against women. In fact, the majority of them, yes, are. But what has happened of late in the past is that men are looked upon in a very degrading and demeaning manner, especially when it comes to rape laws or sexual harassment matters. I think we've seen many movies where these sexual harassment matters take place, and there's that representation where a woman has started to misuse it against a man. She has started to misuse it by seeking revenge and seeking avenging her anger against that man. It could be due to the fact that she's not being promoted. It could be due to the fact that she desired something and she did not get it, or it could be, in most cases recently, uh, you know it has been that live-in relationships where a man and women decided to part ways. A man said, listen, I will not marry you. Of course there are bad cases too, again, disclaimer there. But many men say, listen, I don't think we're compatible anymore, and I don't suggest that we go ahead and marry. And the woman feels cheated, or the woman feels disheartened. She has been probably in a relationship for 5 years, and then she goes to a lawyer seeking help, and the lawyer suggests, or for that matter, she is suggested by friends that, why don't you file a rape case against this man. So here, I think it's a question upon those women, in the sense that should they question themselves before going ahead and filing a case like this? Is because if you were in a relationship for 5 long years, would it not be prudent to presume and assume that there was consent involved? And for 5 years, a man was not raping you, but then these laws are misused. When I say repeal of laws in terms of rape, such rape-related laws, that I don't say repeal of the law in entirety. The idea here that men's right activists, what they come across and what they state is that the idea is to have guidelines in place, certain commissions in place, certain law-making bodies in place, which help form these guidelines and state that yes, in case it's a real issue, you handle the real issue per law. But in case there are guidelines which can help that yes, this real issue, or whether it's real or fake, can be figured through, can be solved through these guidelines, then why not? This in essentiality is how these rights, these men's right activists are looking at. So as I said, they dispute that men as a group have institutional powers and privilege, and believe that men don't have legal rights. Furthermore, they also say that men don't have proper remedies against certain laws like the dowry prohibition, rape, etc. This gives women leverage to misuse it against them. However, as I said earlier, many people are of the opinion that this is an activism, an organizational structure which is undermining the efforts of the feminist movement, but that's actually not true. These are certain statistics out there for your reference, and I think these are alarming and bearing statistics. 76% of suicides are men, 85% of homeless are men, 70% of homicide victims are men, 40% of domestic abuse victims are men. Men are the majority victims of violent crime, 64% serving longer in prison, more likely to be imprisoned than women, and when it's especially the same crime. And that, my dear friends, is the bearing, alarming situation at this point. History of men's right, without going into the details of it, it actually did start very much, in a similar time span of the feminist ideas, initiating, because it's when the feminist ideas and politics started to take place, is when the liberation movement for men, it kind of started in early 1970s, and throughout the course of the history it has obviously undergone many changes and has finally emerged as a movement to help aggrieved men and spread equality in its true sense. So these scholars have obviously mentioned backlash, and I think I've covered it, so I'll quickly straight away jump to the organizations that work towards men's rights. One of them, the predominant one, being Save Indian Family Foundation, SIFF, Avijan Welfare and Charitable Trust, Parito Purush, prevention, of course, of sexual harassment, and many NGOs who work on POSH all across the country. So these organizations tend to hold meetings. They could be in any form. It could be weekly, it could be a monthly duration, it could be as and when you require them to help you. And all these organizations tend to essentially help the aggrieved men when it comes to them being falsely implicated, especially. And I think most of these organizations, in my humble understanding, have been revolving predominantly around laws related to matrimonial laws, because I think that's where the most misuse is taking place. You know, but again, National Commission for Men. You can see this picture here. They're demanding for National Commission for Men, and this is a picture from 2018, if I recall correctly. And again, the demand has been there for many years. It's just that the PIL went to the Supreme Court recently. What is it that the National Commission does? And that's something that many of us fail to understand. I think the propaganda around it, whether good or bad, I think any publicity is good publicity these days, but um, The propaganda behind the need for National Commission for Men, the reason behind it is not just laws related to family law, it's not just laws related to matrimonial issues. I think it goes far deeper and beyond just that. And I think that's what all national commissions do, all commissions which form laws do. And similarly for National Commission for Men, which I think in many cases, during many instances when I have spoken about it, and when I have spoken to fellow colleagues and people around who are very passionate about this particular topic, and I've come across this one lack of understanding always. Is it just about matrimonial laws? Is it not beyond that? What about mental health? What about fatherhood? What about general health aspects? Um, a lot of people, a lot of reels that you see on Instagram these days, and a lot of information out there on social media has been revolving around औरत है तो ये नहीं करेगी, औरत है तो उसको इस चीज के लिए मना किया जाएगा. But how many of us have seen our men in the family, fathers, brothers, husbands, being able to cry, or being able to, just a minute. Am I audible and is it all good?
Yes,
Yes,
ma'am.
ma'am.
Yes, ma'am, you
Yes,
are
ma'am.
audible.
And I hope everyone's following me through.
Yes, ma'am.
Wonderful, thank you. So, as I said, most of these people have always been around the fact that it is predominantly family law, but none of us realize that men can't, show their emotions quite often. अगर लड़कियों को कहा जाता है कि आप इस तरह के कपड़े ना पहने या रात में बाहर घूमने ना जाएं, उन पे इस तरह के पाबंदियां लगाई गई हैं, इस तरह के कंट्रोल्स लगाए गए हैं, तो क्या आदमियों पर, क्या in general men, don't they face this problem? Men are always told not to cry, are always told not to sit idle at home. They have this constant pressure of bringing food to the table, and with time, with age, when you progress in your life cycle of being in school, progressing to college, and then thereafter progressing to a married life, working life, work life aspects, you tend to notice and you tend to come across many men who are facing a lot of mental health crises. But those very men go back home with a straight face because they have been told and it has been instilled into their systems to not cry, to not show that they're vulnerable, to not show that they're emotional. And as a human being, if you are troubled and frustrated and you're not even allowed by the societal norms to even cry, imagine the kind of havoc and wreck that it causes into your system. And these very men, my dear friends, are also suspects to suicides. It eventually leads to that kind of depression and that kind of severity of frustration that it leads them to those suicides. So essentially, National Commission for Men ideally would look at you know working towards specific concerns such as mental health, fatherhood, workplace issues, educational disparities. The idea behind these commissions would be to raise awareness, handle unique health concerns, and health concerns especially because again men don't know how to talk about these issues. So these kind of commissions maybe can help in those spectrums as well. And of course, the crimes of domestic violence where they are falsely implicated and false cases, that being one part of it too. So yes, bringing the cat out of the bag, the famous case of Mahesh Kumar Tiwari versus Union of India. This PIL was recently filed at the Supreme Court, seeking creation of National Commission of Men. And as I said in the beginning of the webinar, that I am personally again of the opinion that this PIL was narrow in its construction towards the Supreme Court. It was only looking at fears of domestic violence among married males. It was looking at the suicides committed by men who were subject to domestic violence or who were subject to issues happening in the family. But ask yourself as well, dear friends, is it just that? Is the need of National Commission for Men just that? Or is it beyond it? I think it's beyond it. So yes, this commission did show, I'm going to straight go to the statistics here. Did show a few statistics, and these statistics, of course, are alarming. Mr. Mahesh Kumar Tiwari, in his petition, stated and cited the report from National Crime Records Bureau, stating that 1,64,000 people who committed suicide across the country in 2021. Of them, 81,000 of them were men, married men, and 28,000 of them were married women. So, among the suicides that took place, 82,000, this is a 2021 crime report. So, it's not even very old. And he further went on to say that 33.2% men ended their lives because of family problems and 4.8% due to marriage related issues. And in that year, total of 1,18,000, approximately 1,19,000 men committed suicides, which is about 72%. And total 45,000 women have committed suicides, which is about 27%. So, you here see there's this orange line here, male suicide due to marriage related issues, and that's 571. And, the blue reflects that male suicides due to family problems. And then if you see the bigger portion of the pie chart, it's other men. So when it comes to other men, there must have been certain other issues as well. So this other men is also something that I believe should be looked into collectively as the National Commission's requirement. Right. However, this was dismissed by the Supreme Court. But again, friends, I would like to mention something very important here, that National Commission for Men is not the only thing that has been dismissed by the courts. And the courts have time and again mentioned that, even when domestic violence concerns took place, and National Commission of Women in 2014 took some changes up to the Supreme Court and mentioned that, the definition of dowry should be increased and penalty for false cases should be increased. Even that was not looked into. So I think this has, in many ways, in many forms, been a progress of late, been a situation of late where the courts have not taken cognizance of such matters. However, all is not lost, because even though the courts are not, looking into these commissions per se, they are still working very strongly towards, guidelines. And I think you keep reading them. If you do stay updated with the case laws, you may have been hearing quite often that, so and so state's court stated that directions should be passed, so and so court stated that, these should be the way that people should be arrested in false matrimonial cases. And I think recently Punjab and Haryana court has also directed and issued such directions, where they directed to the district magistrates of the entire state, that not to directly and mechanically issue notices to relatives of husbands in domestic violence cases. Essentially, it is to say that, listen, don't just hand out, jail terms to these people and, issue notices to these people. Wait, apply, your minds. Application of mind is important here. Look at the case. Look at the you know incidents that took place. Look at the duration of the marriage. Look at why, the distant relatives are involved. Look at how the FIR has been framed. And again, I think this again comes from experience of, when you read an FIR, most often you see that the allegations are highly vague. They don't hold substance. They don't even hold substance good enough for, breaching the essentials of law, breaching the essentials of that particular section. you know the requirements of that section may say that the crime should have taken place on so and so time, the crime should have actually had an incident to it, but then the authorities are not looking at it. The uh, you know courts are not looking at it and maybe handing out notices to the aggrieved family members. And I think, again, many case laws state that it has become a tendency to rope in the family members to exert pressure on the husband. The idea is, even if the husband has done something wrong, the degree, the severity of it may be this. But then to blow it out of proportion has become the norm because the pressure is to bring in family members of the husband. And there, I dare say, these laws are being misused to such a large extent that it's not just men, it is also females, the women of that family, of the man's family, who are also roped in. Again, goes without saying that we are not undermining the real cases, undermining the women who have gone through such domestic violence. But all the idea here is to mention that there needs to be some thought behind such arrests. So yes, there are. Having said this, all is not lost. The courts are looking into it time and again. There have been guidelines, there have been landmark judgments where the courts have held that men should have rights, or the rights should be gender neutral, so that both men and women, are benefited from it. Having said that, I'm going to now focus on how these laws are neutral and how they can be used by both men and women, and especially by men, because in this instance, men don't tend to know about them, because of late it is mostly women rights or feminist rights that have been in the news. So what are these laws? These are spaced out all across, the uh, legal provisions available. However, we're going to segment it into certain acts so that we help you understand which all these sections are. So yes, Section 10, judicial separation, is gender neutral. Section 11, void marriages. Section 13, divorce. Section 24, maintenance pendent light and expenses of proceedings. Section 25 and 26, all of these fall under Hindu Marriage Act. Um, all these acts have in the past been used badly in wrong ways by women, but of late these are being equally used by men to assert their rights out there. And again, this comes from experience. This comes from doing these things on a regular basis in court. And when it comes to, just a minute, are there any questions at this point before I head into this category of the presentation today? Or should I continue?
Ma'am, I have a question.
Yes.
I'm sorry for the video, but I don't have a nice internet connection over here.
That's not a problem.
Uh, Thank you, ma'am. Ma'am, I have a question in the sense that when we are speaking about this men's commission and the women's commission, I understand that the many of the laws are misused against the men. But why don't we just stick to the National Human Rights Commission, which is there, and we just abolish the women's commission as well, and just keep the Human Rights Commission so that the equal rights can be granted not only to the men and women, but also to the other genders of the society?
Um, I think to that my counter would be the Uniform Civil Code, because I mean, there's no denying the fact that there is huge talk about the UCC, and I think you're all aware of it as at that stage of your careers, there that gender neutrality and gender equality would be predominantly met if UCC comes in place. So, so to say, to your directing it to your question, that why don't we abolish women, National Commission for Women? I think it's asking for too much, because then you essentially take away the right of me asking for National Commission for Men. Again, the Supreme Court hasn't denied the petition in entirety. They have permitted that this can be represented in front of competent authorities, and that the court is open to hearing this at a later stage. So to say that the Commission for Women should be abolished, no, I don't think that would be a right approach. Or just the State Commission looking into these factors, because State Commission just doesn't look at men and women rights. Again, it has so many other facets. So these kind of organizations are narrower in approach, and they help people in need better. That would be my answer.
Okay, ma'am. Okay, ma'am. Thank you, ma'am.
Yeah. Shall we continue?
the participants have any questions, please raise your hands or drop it in the chat box. Okay, ma'am, I guess no
Yeah.
one has any questions.
Right. So as I was mentioning, these laws are predominantly related to, the current ones that I mentioned are for Hindu Marriage Act, but here I would like to specifically relate to maintenance payment light and expenses of proceedings, because you're all budding entrepreneurs, budding lawyers out there, and you should know your laws well. And off late, I don't know if you're aware of it, and I hope you are, but when it comes to a man initiating a suit for divorce, the strategy of the opposite lawyer is to, and that opposite lawyer has most likely filed a section 125 already, and has most likely initiated a domestic violence case under DV Act already, where in both instances, under section 125 and under the DV Act, that particular lawyer representing the female has most likely initiated maintenance demands. Yet when a man initiates section 13 petition, the next step is that the opposite party will come and file section 24. And what happens then? They're seeking maintenance again. Sometimes, not just that, they also, if the woman, for example, is living in Mumbai and the man is living in New Delhi, the woman is straight away going to move, the Supreme Court with a transfer petition. And, there are n number of cases filed in the Supreme Court which cater to transfer petitions on an everyday basis. This is just a bit of trivia for you all. That's the humongous amount of litigation when it comes to matrimonial laws is out there. So what happens is that the woman moves transfer petition stating, "Hello, I can't travel. It's very difficult for me. I'm a woman. I have a child. I am unavailable to travel. I can't, manage to go all the way to Delhi to fight my cases. I have already suffered enough. There has been so much domestic violence against me. There has been so much drama in my life. There has been so much cruelty in my life. Please transfer the petition to Mumbai." So the man, despite having a right to initiate a case because he has faced cruelty, is now overburdened with travel or with other expenses, because now he has to travel to the city where the woman lives for fighting the case that he has initiated. So the courts in this, very famous case of Krishnaveni Nigam, if you want, I will share the citation with you after the webinar, and I would strongly suggest that you all read it. This is a very famous case because in this particular case, court held that transfer may not be necessary. So here, the Supreme Court mentioned that the wife can be given interim maintenance, travel for, monies for travel allowance, up to the capacity of the man, up to his paying capacity, of course, or the proceedings be conducted through video conferencing. Here, the idea is to not overburden the man or to not take away his right of initiating a case, because essentially then a man, if this were not there, a man would have been left with no choice but to initiate the case in the city or state of where the woman is, and that would have been unfair. So here, through case laws, through precedents, the court has time and again come to the help of men and provided such gender neutral provisions, where although most often section 24 is filed by women, it has, in the recent past been filed by men as well. And the courts have at times, looked at it in variations of approaches, depending upon the case to case factual matrix also. But for example, at times courts do that they'll pay litigation expenses in that, recent case, in the current case example that we've mentioned here of Rani Sethi versus Sunil Sethi, where the court did pay a sum of 20,000 as maintenance to her husband along with 10,000 as litigation expenses. But the courts have also done this. Wife filed section 24, man filed section 24. Court sees the reality of the situation. Court values the assets and liabilities of both the parties, and then the courts say, wait, let's cancel section 24 of both the parties. Let them fight on actual grounds, or at max, because the wife has already been seeking maintenance in other cases, justify the quantum of maintenance. Let's not overburden the man, which we'll come to, in the next slides. Section 25 again here, permanent alimony and maintenance. This is also a gender neutral law. Both men and women can seek maintenance. There is no stopping men from seeking maintenance as well. If the wife is earning enough, the man can also seek maintenance. I do believe it's not all hunky dory. At times, there are judgments, there are statements from learned judges. Again, not overstepping on anyone's toes or uh, hurting anyone's sentiments by stating this here, but I would like to highlight that the approach in general is that if a man is able bodied, if a man is capable of earning, he, even though section 24 and section 25 are gender neutral, he will not be granted maintenances, because the courts are of the opinion that it may promote idleness, that it may promote section 26. As I mentioned, you know, again, child custody
Hello,
has.
ma'am.
Yes.
Ma'am, excuse me. Ma'am, you were disconnected in between.
Okay. So where was I in the end? I'll continue from there.
Ma'am, you were discussing about yes, ma'am, you were discussing about that uh, problems faced by men with this travel.
Was I at section 25?
Yes, ma'am.
Okay. So can anyone tell me what were my last discussions so that I can take it forward from there?
Ma'am, you were on section 25.
Okay. So section 25, as I said, can be gender neutral as well, but judges have in the past passed on certain statements which tend to undermine the effect of these sections, where they state that if men are granted alimony, or if men are granted interim maintenance, then they will be subject to becoming idle. It will promote idleness, and therefore if a man is able bodied, he must not be seeking interim maintenance or permanent alimony. So section 26, child's custody. Again, I think I did mention this in the initiation of the webinar, that child custody is a rare scenario where men get it. Although we have been lucky enough to have managed custody for our clients, especially them being males. Although it is, albeit at the moment it is interim custody, but from the situations of the case, it looks like it will go on to become full custody, permanent custody of the children with the man. But it's a rarest of rare case, and it is mostly that men are not granted custody. Of late, courts have, in various cases, the ratio, I dare say, is, and if you were to actually look at statistics, it would be 1 in 10 cases where a man gets custody of the child. Otherwise, predominantly, it is women. The courts are to look at the welfare of the child. The courts are to look at whether the child would be more benefited, most suited to live with the father or the mother. But the general tendency, and here I believe we all agree, that it is the human psychology at play, because even the people, the competent authorities sitting at that stature are human beings. And as our society, it has been the norm that a woman tends to take care of the child. Women give birth, and therefore women are pre-equipped, mostly equipped to handle the child, and therefore the courts have in many instances directed the custody to the woman. And There have been instances of parent alienation, father's parental rights being alienated, right alienation, the father being used as an ATM, the father being used as a money machine, the father being used only to be provider of necessities and not being catered to in terms of, being a decision maker for his children. And that has been changing. The shift is slightly there, but these kind of cases have to reach at the High Court level or the Supreme Court level for that kind of grant to be provided. District courts are still predominantly regressive in that approach, and they tend to grant custody to the women more. Laws that help women, Criminal Amendment Act 2013. It's a gender neutral view towards acid attacks and attempts to acid attack. Anyone, regardless of the gender, can file a complaint under the sections for acid attack and attempt to such attacks. Equal remuneration, and I think, again, it has been much talked about. Although men haven't really faced this problem, yet the law is gender neutral, is the point that we're trying to make here. Section 41A of the Code of Criminal Procedure. I think this particular section was the game changer when Anish Kumar versus State of Bihar took place, and I think it was a game changer for all Section 498A Indian Penal Code matters. This is 2014, and not only did 41A do this for matrimonial related issues, 41A became a game changer for all offences which are, the degree of such offences is below 7 years. And Anish Kumar versus State of Bihar became the crucial point in 498A matters, where 41A was introduced in CRPC, and I think ever since then it has been a game changer in these cases. Also, I would refer to this one particular case, keeping in mind keeping in mind Anish Kumar. Rajesh Sharma versus the state of UP. It's a 2017 case, although I believe it has been overturned. But the idea here, and in many such directives from the Supreme Court, there was another directive and guideline on 498A matters, was that husbands' relatives cannot be forced to undergo trial in absence of specific allegations of dowry demand. And there was another case of Mukesh Bansal versus State of UP in 2022, wherein the court stated that allow them 2 months cooling off period before you actually, initiate arrests and issue Section 441A notices. Issue notices under this section because, hello, it's not a severe crime. Please do not overcrowd our jails also. And this was attempted at, reinitiated by the Supreme Court during COVID. During COVID, courts were like, already India is an overpopulated country. Let's not overpopulate our jails. So if any crime is of a nature which is the severity is low, the person can be, we all agree and we've all read about it. Bail is the rule, jail is an exception. And with that in mind, courts have time and again stated that don't arrest a man or a woman or anybody for that matter till it is absolutely necessary. And as I said, COVID reinstituted that norm into the system, and police officers and authorities were informed once again, use Section 41A. Don't just put them in jail. Don't fundamentally arrest them. Investigate. See if the case has merit. See if this is a case which warrants genuine requirement. This is a genuine case of domestic violence, and see if it is probably not a civil case, but with a garb of a criminality. If that is the case, then hold on, don't arrest. So, the other laws that talk about gender neutral laws, I will come back to Anish Kumar and Rajneesh Neha because these are landmark judgments and I would really like all of you to know them from the point of view of a practicing lawyer. Right, so before that, I would just quickly brush through the gender neutral laws. How much time are we left with, if I may ask, so that I'll brush up accordingly?
You can continue.
Sure. Thank you so much. Right. So, just a minute. Yeah. So, gender neutral laws. Of course, Section 324 of the IPC, voluntary hurt with a dangerous weapon. It can be through, conducted through a woman or through a man. It doesn't matter. It's a gender neutral law. Uh, Conspiracy 120B. Conspiracy can be done by either genders. Section 506, criminal intimidation. And here again, I would like to mention that criminal intimidation is, contrary to popular belief, is being misused by women as well. Because I think in the age of internet and in the age of digital era, everything being so easily available, criminal intimidation has become the norm, and women tend to misuse it too. Against men, of course, especially men who are in live in relationships. Quite often, more often than not, we come across those cases in our district court fora where we see that the criminal intimidation took place by a woman and her family and friends against a man who refused to marry the woman due to so and so reasons. So these are some other sections where, of course, you can move the complaint through the magistrate, local magistrate of your jurisdiction, where upon examination and oath of the complainant, witnesses present, the statements can be corroborated and eventually lead to an FIR being filed. Section 167, if there's a public servant, of course, these are all gender neutral laws. Why I've mentioned these laws here is for all of us to know and understand that these laws can be used by men as well. 191, where if you have committed perjury, if you have made any false statements, that can be taken up against you. Section 27 of the Special Marriage Act deals with divorce petitions on the grounds of cruelty and harassment. 377, I think then again, this is a topic which is, in all humble reality, a very, very sensitive topic, because no one has actually ever thought that a woman would be able to rape. And yes, undeniably, it is women who are facing the atrocity of these crimes more. But does it mean that men will not be raped? This section does recognize men as victim of rape, but does it uh, believe or presume that perpetrator would be a woman? Most often not. And I'll tell you a very interesting story. I was just going through it. I can't verify the authenticity of that reel, but such is the world of reels these days. I was going through this particular reel a couple of days ago, incidentally, that there was a man in early 1800s. This is before the Renaissance period, and this was a man of African ethnicity who was a slave, but he was a very good-looking slave, and because he was good-looking, he was very humble, he was very intelligent. He was used by women of the privileged strata to get pregnant by him so that they could have a good progeny. And that man was a father to more than 100 children in a span of few years. So would you then, in that instance, think of it like that man was particularly being used with or without his will because he was a slave? And then would you constitute that to be rape? So this is food for thought that I leave for all of you. Of course, I don't know what happened of him. Was he? I think, as far as I understand, because he was a slave, a loyal slave. He was humble. He would never speak up. He was given certain privileges, more privileges in comparison to other slaves. But as I said, I would leave that as a food for thought for all of you. If anyone comes across the veracity of that particular reel, I would really appreciate you sending that across to me. Right. So, prevention of sexual harassment at workplace. I do happen to take many these posh related workshops, with one coming up tomorrow morning. It's a common misconception that posh is specific to women, and that men or male employees are not covered under it. Well, let's break the myth here. Men can also report such sexual harassment, complaints, and they can register these complaints with their HR department, with the internal complaints committee. And the usual requirement of all good organizations is that they promote gender equality in their systems. Senior citizens, so when it comes to men and when it comes to their parents, suppose a case was filed by men, in by women against men, and they roped in the parents of the accused as well. There, most such parents don't know what to do, and they get caught in the garb. Most often, lawyers don't tell to, or people are unaware, I believe, that there is a Senior Citizen Act, which is popularly known as Senior Citizens Act, and was enacted in 2007. This act particularly effectuates methods and measures which are inexpensive and speedy in nature for senior citizens who have been privy to such false cases, or otherwise also if they have been misbehaved with, either by their daughters or segments of the society. So again, something which is a provision available for men and women alike, especially for their parents, that they can look into it. Coming to the most important judgment in the past that I have uh, come across, and I think it has been a game changer for men in general, because there was undeniably a tendency and a strong tendency of roping in men in false cases, especially with respect to maintenance laws. And Rajneesh versus Neha came with a bang in 2020, with a guideline, an entire format of an affidavit of assets and liabilities, the disclosure of assets and liabilities. And I'll just read out this to you, the judges to you, Indu Malhotra and Subhash Reddy. I think I bow down to them for this beautiful piece of art. I call it art because it genuinely has been a game changer, gender neutral, predominantly effectuating maintenance laws in the country. As I said, game changer. It mandated affidavit of disclosure of assets and liabilities. It mandated that both parties are to file it. Earlier, this affidavit was prerequisite for men. Income affidavit was prevalent, was there, but it was a prerequisite for men. Women were never asked to file it. But Rajneesh versus Neha broke that barrier. It said, hello, wait, women are earning too. Women need to showcase their assets and liabilities as well. Men, yes, but women too. And there, the courts have also effectuated quantum of maintenance. They have effectuated what should be looked into. And let me just quickly, rush through the case law here and read out few factors to you. If I can find it, I seem to have not marked it here, but hopefully, yeah, here it is. So, the courts have said you have to look into all factors. You have to look into what is the need of the children. You have to look into what is the need of the woman. You have to look into what is the need of the man. You have to look into a man, if he's earning an X amount, he should be able to look after his age-old parents. He should look after his children. He should look after his wife, but he should leave some money for himself as well. And how do you do that? You have to look at the fact that before marriage, during marriage, and after marriage, the strata of both men and women, the strata of living, the style of living should remain the same. It should not degrade. And therefore, or if it should not, it should not, be stagnant. It should increase as per the need of the hour. This happened through Rajneesh Neha. I think a mind-blowing judgment like that. It's a long judgment. I believe it's a 256 page long judgment, 200 plus pages, but must read for all of us, even practicing lawyers, because more often than not, people tend to not be aware of this judgment, although it has become a mandated requirement and judges ask for these affidavits. But just not the affidavit is the beauty of this judgment. It is beyond it. It is the way the courts have stated quantum of maintenance should be decided. If you recall, I was mentioning that under Section 24 applications, the opposite party has already initiated Section 125, already initiated Domestic Violence Act. More often than not, opposite party has also initiated other sections of maintenance under Hindu Adoption and Maintenance Act, Guardian and Ward Act, etc., etc., where so many cases have been filed against the man. What is going to happen if another section 24 comes through? Maybe another 10,000 is decided against him and in favor of the woman. So no one did actually apply their mind to the fact that already 4 cases are ongoing. पांचवा case भी add हो जाएगा. Fifth case is going to add more money onto that man's liabilities, and he's going to be overburdened by them. Man's got to eat himself as well. He just doesn't have to feed his family, estranged family, estranged relationships. He has to feed his age-old parents, maybe a disabled child at home, maybe an unmarried sister at home, etc., etc. Those are all dependents on the man. So the court has laid down wonderful guidelines on the quantum of maintenance, and the courts have also stated if the man is not paying arrears, then what needs to be done, whether there is contumacious intent, whether there is willful disobey or disregard of the court's order, etc., etc. So yes, Rajneesh Neha has been a game changer in terms of gender neutrality, and I dare say it actually helped men more than not helping them. Anesh Kumar, I did touch base upon it. Again, the courts mention the court mentioned in 2014 that this was an endeavor to guarantee that police officers don't capture the charged pointlessly. They don't just catch hold of them and put them behind bars. The idea was to be careful, approve detainment nonchalantly and precisely in cases under 498A. Court gave certain directions. Nonetheless, the directions apply additionally to different situations where the offense is guilty, with the detriment of not more than 7 years. So essentially, the court said, listen, if it's less than 7 years, hold on, see if the accused is actually guilty or not. And therefore, 41A came with checklists, which ideally is to be checked by a police officer. So how it happens these days is the minute an FIR is issued, FIR is created, uh, and the duration between an FIR and a charge sheet is more often than not far beyond the stipulated period of 30, 60, or 90 days. And I think we all know that the real ground level situation is grim. It's rarest of rare cases where charge sheets are filed within a stipulated framework of CRPC. So what happens is the police officers have now started to do this. Go back, cut to the same conversation I had. COVID. COVID again, Supreme Court said, hello, don't start pushing people to the jail. They're already overburdened by people. So again, the police officers have started to do this. They do this checklist, whether the man is cooperating in investigation, whether the man, each time they call him for, statements under the relevant provisions of CRPC, whether he or she is appearing in the court to give their statements, whether the man is cooperating in these services, whether the man is diligently available for counseling, for such, requirements of the police. Therefore, these certain checklists are covered, and police issues Section 41A notice to the accused till the time he agrees to help and participate in the investigations, does not abscond the country without permission, and various other factors. The police is not going to, the authorities are not going to arrest them. So these guidelines were directed to first attempt mediation and reconciliation. Go back to the fact that Mahila Counseling, Mahila Helpline gave birth to this particular factor where mediation and reconciliation. I think Hindu Marriage Act, Special Marriage Act, all these acts, family courts in general, if one were to read the Family Courts Act, one would know that the objective behind Family Courts Act 1984 is that people, the courts, the entire system per se is aimed towards mediation and reconciliation for failed marriages. The idea was to ensure that prima facie, unless there is evidence of the accused being involved in harassment or cruelty, hold on, don't arrest them. Hold on, try and mediate this, try and reconcile the family, try and reconcile the estranged couple, because more often than not, it is not just the man, it is not just the couple who is suffering. It is also child, the children of that particular couple who suffer if the marriage goes wrong. So yes, the idea of this particular judgment was to look into all these fair investigation procedures, and it was a great step towards abolishing discrimination and misuse of the law. So all is not lost, as I said. National Commission for Men may or may not have been initiated, but these judgments do come as best friends to men in the time of need. Awareness is, I think, the most important tool here, um, especially in fake cases of domestic violence in 498A. All these various organizations I mentioned earlier have been helpful in propagating awareness and ensuring that men get their rights appropriately. And SIF, Safe Indian Family Foundation, being one of those organizations which have been at the forefront, working closely with other organizations spread out across the country. And I think this is something you all would like to take note of. This is very, very a specific to case laws, procedures in courts where these procedures help in terms of remedies, help in terms of fighting false cases in court. Mahila helpline is not just for Mahila helpline, contrary to the name. Men can actually also seek counseling here. CRPC relevant provisions, complaint can be moved with the magistrate seeking relief. Husband can file a petition under Section 13 of the Hindu Marriage Act, under Section 27 of the Act. He can file for interim maintenance under Section 24 of the Hindu Marriage Act. Section 9 of Hindu Marriage Act and Section 22 of Special Marriage Act specifically looks at restitution of conjugal rights. And if your wife has filed a false case, if you were not at fault, if she left you voluntarily, restitution of conjugal rights is your best friend in such cases. Man can also seek relief for quashing of FIR in the higher courts, especially of the state, High Court of the state, by seeking quashing of FIR. Later in the stage of divorce or maintenance procedure, if mutual settlement does take place after a few years, then you can take that compromise to the magistrate where your Section 498A case is ongoing and request the court to make it compoundable per the procedures of law. Suit filed under 498A and charges are framed, then he can request even to the police. The first thing that the person, for example, someone in your family, and God forbid it happens, but if it does, then you must inform people. And even as lawyers, you should always guide your client to say that, wait, if 498A has been initiated against you, ask the police if they come to your doorstep, have they been in compliance of Section 41A notice? Have they issued a notice to him? Also, one can seek anticipatory bail by moving the Sessions Court and the High Court. It is not necessary to move for anticipatory bail if compliance has taken place under Section 41A. However, at times there are various factors in play, and there, depending upon the factual matrix of the matter, it is suggested that one seeks anticipatory bail. You can also write to officials and higher authorities like the SSP, DGP, Chief Justice of the concerned state, where matters have been falsely filed against you. You can also file a right to information, application against your wife, under the Right to Information Act, by seeking documents which reflect her income or reflect various other positions, liabilities, and assets that she owns. Also, a section which is not predominantly used is the Section 7 of the Family Courts Act, where not only can a husband seek injunction from his property, a husband can also seek matrimonial properties under this section in case he has purchased it in the name of his wife and the wife is misusing it now because so many ongoing litigations are happening and she's refusing to give the property. Courts have in the past held that if a man's money was involved in buying, hard earned money was involved in buying that property, then that property belongs to the man. If a woman is harassing you in your workplace, at your house, then you can seek injunction under Section 7 of the Family Courts Act as well. However, please note, Section 7 can only be initiated if the dispute is between a husband and a wife. Any other member of the family, Section 7 may not apply. affidavit of assets and liabilities. Here, Rajneesh versus Neha, the husband can press for contempt of court and may also constitute an offense of perjury under section 340 of CRPC. So yes, these are some of the remedies available, procedures available for men in case they are falsely implicated. And with that, I come back to say that the rights movement, the men's right movement, has been about gender inequalities and challenges contrary to popular belief. By advocating for men's unique circumstance, equal treatment, fairness, and consideration of men's unique circumstances, the movement promotes gender equality as a whole. As I said earlier, it is crucial to approach these issues constructively and not be negative. Don't think that, oh, men don't have rights, oh, women don't have rights. Don't objectify them, put them under cages of gender. Look at them as human beings. Work collaboratively to create a society that acknowledges and addresses the rights and concerns of all its members, irrespective of gender. The idea has been all this while gender equality and gender equity, gender neutrality. And my dear friends, with that, I close the topic for today. I do hope and believe it was interesting for you and you enjoyed it. Thank you very much.
Thank you so much, ma'am. It was an insightful session. I would request all the participants, if you have any questions, please write it in the chat box or raise your hands, and I'll just call out your names one by one. You can ask it to ma'am. Diantha Kumar, please unmute yourself and ask the question.
Uh, Good evening, ma'am. I'm a first year law student from Okajandar Global University. My name is Dianta. In the first segment, you discussed how a live-in relationship of 5 years when parted ways, then the female in the live-in relationship was given ideas to file rape case or something like that. So, as per my understanding, live-in relationship have given equal recognition as a married couple in
Yes.
India and
Yes.
equal protection. And in that scenario, doesn't marital rape, since marital rape is not a crime in India and has not been criminalized, so the same aspect can be inferred in the live-in relation couples as well.
It can be Dayanta, right? If I pronounce your name correctly.
Ma'am is Dianta.
Dianta. Dianta, see, again, factual matrix in a case will decide the real course of action for anybody. So when it comes to such, advices being provided to women and then those women misusing them, more often than not, the kind of picture that they project to the officials, the authorities, is that the rape took place outside of such a live-in relationship. The idea for those cases is to take revenge. That essentially was the reason I gave that example. Goes without saying, yes, marital law is decriminalized, marital rape is decriminalized to the extent, especially live-in relationships, are considered equal to uh, a husband and a wife's relationship and fall under Section 7 of the Family Courts Act as well. There are various case laws which state that. However, because the way you project your case to the police authorities, the officials, the idea here is there misuse? And yes, there indeed is. It is about the factual matrix of each case. I hope that answers your query, Dianta.
Yes, ma'am, it does. Thank you so much.
Any other questions? I don't see any other questions in the queue, Pratiksha.
Yes, ma'am. Thank you so much, ma'am, and thank you so much, Dianta. If there are no Ma'am, there are questions in the
I think it's showing.
chat box.
Yeah.
Ma'am, is live-in relationship legally valid? Raghav Sharma is asking this question.
Yes and no, in terms of again how long the relationship was, what kind of an intention was there. But predominantly, yes, of late there have been various precedents where, especially the Supreme Court has actually looked into the matter with detail, wherein the courts have stated that live-in relationship of a certain duration will be considered equivalent to a marriage, and yes, therefore legally valid. I think, Raghav, again, I'll go back to that point. My experience of 11 years has taught me only one thing. You look at the case per the factual matrix of that case. It would be unfair to put it under a bracket. Precedents can be used for and against. So, and there are plenty out there. So, yes, 1 year of relationship, to answer that question straight up, would be considered valid and would be considered, you know, legally enforceable by a woman or a man if they ever wished to do so. Are there, I don't know, I think maybe they're coming in due to.
I guess there is no questions.
Okay.
Uh,
So,
Thank you so much, ma'am, for your time. Ma'am,
pleasure is all mine, Pratiksha. And,
ma'am, Nafia, do you have any question? Yes. Ma'am, thank you so much for your time. I would like to express my gratitude towards you for sharing your valuable insights and taking the time out of your day to grace us with your presence. Thank you each and everyone for attending this webinar. It was great seeing your attendance at this event. Thank you to all those who have made this event possible. Thanks again, and we hope to see you again at any other important events out there.
thank you so much. Thank you, everyone. I hope you enjoyed it. And if you have any questions, you can write to us. Um, I believe Amicus Curiae would provide you with the details and we'll be more than happy to look into them for you. Thank you so much once again.
Thank you so
Ma'am,
much, ma'am.
I guess Jasmeet is having one question.
Okay.
Jasmeet, do you have any question?
Yes, I'm so sorry I was not able to ask it, having some network issues.
No issues. You
So,
can
ma'am,
ask it.
I wanted to ask, the PIL was filed on matrimonial grounds only. So there was none other ground, right?
To be very honest, the whole matrix revolved around matrimonial laws predominantly, but no, they did mention that there were certain cases of suicides by other men as well. If you recall, I showed you that pie chart. But predominantly, yes, because that has been the major concern of late. So yes, this PIM was looking at matrimonial laws more than the whole essence of national commission for men.
Okay. And the PIL is not exactly rejected. Uh, you said
It's
that
rejected
it's
for now. Rejected for now, but open to the extent that the courts will be open to looking at the PIL at a later stage with more nuanced approach. And right now, the Supreme Court has mentioned that you can, and I'll quote it for you if you want me to, that you can take it to the relevant court, competent authorities for now, and then later you can, take it back to the Supreme Court in the form of either a PIL or in other aspects. But per se to form National Commission for Men, the courts actually didn't listen to it much, at least in this PIL.
okay, ma'am. Okay, thank you.
Most welcome.
Thank you so much, ma'am. Thank you, Jasmeet. I hope everybody's queries are answered. Thank you so much, ma'am, for your time once again.
Thank you so much. Can I get the details of this from, I believe, Rupam or you, Pratiksha? I believe there was a
Sure,
unit
ma'am.
for this.
Yes, ma'am, there is one.
Could provide those details to me through
Yes,
email.
ma'am, we'll send you the link. Yes, ma'am.
Thank you so much. Thank you. All
Thank
right.
you, ma'am. Thank you.
Thank you,
Bye.
everyone.
Thank you, ma'am.